Good morning, everyone. We'll just wait another minute while we're letting everybody in, and then we'll get started. All right, we're going to get started now. Thank you so much for attending today's webinar. My name is Sharon Rich. I'm the Director of Trust Services for Aged Trust, where we manage special needs trusts for seniors and persons with disabilities who need to qualify for Medicaid and have too much money. Aged's Pooled Trust was established in 2004, over 20 years ago. We're in Central Florida, but our services cover the entire state of Florida. And all of our clients are on some kind of government benefit, so we know a lot about Medicaid, Medicare, Social Security, disability, and we love you to use us as a resource. So please feel free to reach out to us at any time. Today's program is approved for continuing ed credits for guardians and attorneys and is being recorded. You will receive an email from Kate at trustaged.org within about 5 business days after the program, and that will have a certificate of attendance, a copy of the presentation, and a link to the recorded presentation. If you have attended our webinars previously, you are used to getting your certificates within a couple days. We have a large event going on tomorrow. Some of you know what GSI is. And so your CE is going to take a little longer than usual. Please be patient and really don't expect anything for like a full week from us. So thank you so much for understanding. Today, please put questions into the Q&A box, not the chat. You may have to click your little button that says more to find the Q&A box. That is the best way. We will leave time at the end. And you will be provided with the slides later when your CE information is sent. I am so excited today to introduce our speaker, whom I met at a conference a few months ago. Our CLE presenter is Sonia Munoz Gallagher, an estate planning attorney and founder of Family Wealth Law, LLC, where she focuses her practice on estate planning, probate administration, guardianship coordination, Medicaid planning, special needs planning, and business succession. With more than 20 years' experience practicing law in Florida, Ms. Gallagher works closely with families, fiduciaries, professional guardians on complex matters involving long-term care planning, public benefits, and coordination of legal authority across multiple fiduciary roles. Her work frequently involves guardians and attorneys navigating the intersection of trust planning, public benefits eligibility, and court-supervised guardianships, particularly when protecting individuals who depend on Medicaid, SSI, or other benefits. So she's a perfect background for our audience today. And she will present coordinated long-term planning, protecting benefits authority, and continuity of care, where she will discuss emerging fiduciary risk trends and practical coordination strategies for professional guardians. So I am now going to turn it over to Sonia.
Good morning, everyone. Can everyone hear me? Okay.
Yeah.
I'm happy to be here. Thank you for being here to learn this morning. Um, as Sharon said, my name is Sonia Munoz Gallagher. I'm an estate planning attorney. I'm the founder of Family Wealth Law, a law firm in Broward County that covers the whole state of Florida. Today, we're going to talk about coordinated long-term planning in guardianship matters. In specific, we're going to talk about how guardians, attorneys, trustees, and planning counsel all work together to protect benefits, to clarify the authority, and to maintain the continuity of care for the vulnerable individuals that we serve. Many of the situations that we'll discuss today arise in real guardianship cases, situations involving inheritances, trust structures, Medicaid eligibility, Social Security benefits, and coordination between the multiple fiduciaries. And my goal today is practical. It's to share insights from real cases, real life examples, so that the professionals involved in guardianship matters can recognize potential issues as early as possible and prevent problems and crises from happening later on. Okay. So a little bit about me. I do estate planning, guardianship coordination, special needs planning, Medicaid planning, business succession planning, and fiduciary coordination. But a little bit about me on a personal level. I am a mom to two kids. My little one's 9 and my older one is 14. My older one is on the spectrum. She is a little genius. Sometimes she acts like she's older than me, and sometimes she does not. So it depends on how the wind blows that day. She's what is typically called high functioning autistic, and there are now other things that are coming out, unfortunately, other syndromes. So she's my primary reason for going into this type of law. And I work very, very actively in the special needs community. I've also got a grandfather who is my sunshine, and he's 101 years old. And my mom takes care of him. And he is as lucid as can be. He's more clear than me sometimes. Brain fog is a real thing, especially at this age. And Abuelo is my motivation for helping all the elder clients that I have. So I truly love what I do. It's not just documents, it's lives. Lives of people that sometimes are in very sad situations. So the type of work that you do is really valuable. And I thank you for what you do because sometimes I know that some days are just really hard. And sometimes the families are the hardest thing to work with. So know that you're making a big difference. Okay, back to the presentation. Much of the work that I do involves situations where much of the work that you do involves many legal roles happening at the same time. So, for example, a ward may have a guardian, a trustee, a healthcare surrogate, a power of attorney created before the incapacity happened, and sometimes several family members that also have votes and a voice, and sometimes are trying to help, sometimes are not, depending on the situation. And you've got to deal with all of these personalities and people and agendas. So, a large part of my practice involves fiduciaries and families and resolving situations where the benefits were accidentally disrupted or where planning needs to be cohesive with the goal of that individual so that benefits are not disrupted. Okay. Usually, no one involved is trying to do anything wrong. It's just that the professionals involved did not have an opportunity to coordinate early enough or just did not know who to speak to about it. So, let me give you a quick example that shows why this is important. And I want you to know that situations like this are more common than most people realize. A few years ago, I had a call where a young adult with disabilities had been receiving SSI and Medicaid for most of his life. His grandma had passed away and left him about $40,000-$50,000. The family thought that they were doing the right thing, so the funds were distributed to him directly. Within a few weeks, his benefits were suspended. Medicaid was threatened immediately. The family was shocked because they believed that they were going to help him with that. He was a young adult. That would make a big difference in his life. Well, the reality was that they just did not realize how benefit rules work. We were able to stabilize the situation, but it required emergency planning that could have been avoided within with just a 5-minute conversation, clarifying everything ahead of time before that distribution occurred. And that happens often, not just from inheritances, but also from awards and settlements. And we'll talk about that. I'll give you more examples. So situations like that are why coordination between the guardian and the estate planning attorney is very, very important. So let's continue with the next slide. Okay, so we've got 3 pillars of effective, sorry. Okay, 3 pillars of effective uh, guardianship coordination. Okay. The first pillar is protecting public benefits. Okay. This is programs like Medicaid, supplemental security income, anything like that that can destroy, that can really, really harm someone's life. The financial decision can disrupt that eligibility quickly. Okay. The second pillar is aligning the legal authority. Guardianship doesn't really exist alone. There could be trusts, there could be inheritance that are coming, there could be powers of attorney that are still valid because they were created before the incapacity happened. And there can be healthcare surrogates that are also involved at the same time. And then the third pillar is preserving continuity of care. This means ensuring financial resources and fiduciary roles remain stable over time for that individual. We'll also discuss practical risk mitigation strategies within the real world examples. So, one of the realities of modern guardianship right now is that these cases involve multiple systems operating at the same time. So we've got Medicaid eligibility rules. We've got trust administration. We can have medical care coordination. We can have family dynamics and of course court supervision over all of it. So you frequently operate, at the intersection of all these systems happening at the same time. And sometimes a decision that seems very straightforward in one system can actually have a big impact in another system. So, for example, accepting the funds for the ward may be very helpful, but that same action can also have a very harmful impact on Social Security benefits or eligibility if it's not structured properly. So, what do we do when it's an example like that? When it's something like that, you would seek counsel from an estate planning attorney that works with special needs trusts. Okay. Basically, when an individual receives benefits, Social Security or Medicaid, the amount of money that they're going to inherit or that they're going to receive because of an award from a car accident or any type of situation where a personal injury case, basically, if it goes directly to them, then it disqualifies them. It has to be put in to a special needs trust. Okay. And a guardian is able to do that, but not immediately. There's a whole protocol for this. You have to seek out the authorization from the court. Typically, the criteria for the court to be able to approve and grant you as the guardian, whether you're a professional guardian or a non-professional guardian, you are able to open a trust for your ward if, number one, the individual will benefit from it. So that's the number one criteria that the judge looks for. Number two, it does not go against the goals or the intent of that individual. Because if there's a will or something already created before the ward became incapacitated and it contradicts the trust that you're going to try to create, like a special needs trust, then there's no way. And then the third criteria that the judge will look at is whether it is in fact a special needs trust. It cannot be a probate avoidance trust, which is a revocable trust that you use to designate the restrictions for your children or grandchildren, and the main goal is basically to protect the inheritance from having to go into probate. It cannot be merely for asset protection, and it cannot be what's the other one? It cannot go against what the individual has already stated in previous documents. So that's important for you guys to know. And at the end, I have a QR code of all of these things that I'm speaking about um in a guide that I created for this audience. So, okay, we're seeing a lot. I do these types of cases often in South Florida, and actually North Florida. I've got three right now in Tampa, in Hillsborough County, and there's definitely an increase in judicial scrutiny over fiduciary conduct. So, for example, a guardian might approve a large financial expenditure without documenting how the decision benefits the ward. And courts will review that later. And they will often look closely and ask for documentation. So you have to be very, very precise and document oriented, and basically just document as much as possible in all of the transactions that you do. Um, Fee
So,
petitions,
Sonia, can I interrupt you for just a
sure.
moment?
Mhm.
Your slides are not forwarding, so we're still on your very first slide.
Oh, let me see. Okay, let me see. Um,
There, okay. Now I see the complexity of modern guardianships.
okay. Technology, gotta love it. Okay, so let me see if I see it. Okay, okay, I've got it. Okay, so okay, complexity. So the guardian's in the middle, and the guardian is dealing with always protecting the Medicaid eligibility of the ward, SSI eligibility, assuming there's court supervision the whole time, dealing with the family dynamics, and dealing with the medical care and the trust structure, assuming that there is a trust already in place or you're going to be creating one. So it's a lot, and you're in the middle of all of it. And that is why it's so important to have an estate planning attorney that works in both scenarios, the guardianship and the estate planning, because that's how they understand what you're going through. So I already spoke about the Social Security being affected, the trust. Okay. So when you need a trust, it has to, I gave the criteria already, what the judge will look for. The judicial scrutiny is increasing. Um, for example, another example is they look at the benefit preservation the whole time. So if a ward loses SSI or Medicaid because funds were distributed directly to them, they are going to examine whether the guardian is at fault. They're going to see if you did your due diligence, whether you're going to have to show, it's up to you to show to the judge that you evaluated that risk ahead of time and comprehensively. So the word is due diligence. That's what they're going to be looking for. How do you document that? Having proof, basically, contacting an attorney, having it in writing, etc. Figuring out why it wasn't a good idea to have a special needs trust, whatever the situation calls for. So the solution often depends on, how the funds were received and whether the planning could be done. before that benefit was affected. So let's talk about the SSI in 2026 and what the requirements are, the criteria. For the limits in 2026 are approximately 2,000 for an individual, 3,000 for a married couple, and these limits apply to countable assets. So even a modest inheritance can exceed these limits immediately. And then for Medicaid, excuse me, eligibility rules vary depending on the program. But for long-term Medicaid, asset limits are typically around 2,000 for an individual applicant. And the income cap for 2026 is about 2,900 a month. So what this means in practical terms is that even a small amount can affect eligibility. So you have to be very alert to that. So one of the tools that is the most common is a special needs trust in order to protect that eligibility to receive benefits. A properly structured special needs trust allows the funds to be used for the benefit of the ward without the money being treated as the ward's personal assets. That is the power of a special needs trust. So in guardianship cases, the trust may need to be created with the court approval, of course. So let's say that the ward receives an inheritance or receives a settlement from a previous case. The guardian is still going to need to petition the court to authorize that creation of a first party special needs trust. Okay. And that's going to be funded with those assets that would come in from the award or from the inheritance. And the trustee that manages those funds for supplemental needs, for example, for therapies, education, transportation, a lot of times it's used for assistive technology, machines that help quality of life expenses, and anything else that's necessary, like similar to that, and it doesn't affect the Medicaid or the SSI eligibility. So that's important. I had a case where a pretty young adult was in a car accident and had a traumatic brain injury and was deemed completely incapacitated. And he received about $96,000 from a lawsuit. And it ended up, thank God, it ended the personal injury attorney ended up calling us on time, and we were able to make the special needs trust right away. Um, and it was funded and it was okay. But a lot of times, we're in Florida, there's a lot of car accidents down here. A lot of times people end up, it's not necessarily that the ward has dementia and it's an elderly. This also happens to people that become incapacitated from a simple car accident. So these things happen at different ages. So it's important to keep that in mind, that it's not just, money that comes in from an inheritance. It can also come in from a car accident, from a medical malpractice situation. Anytime that it's a certain amount of money, you have to immediately think, okay, is this person on benefits? Okay, I have to protect them. So what else? So guardianship overlaps with other roles. So let's talk about other people that are involved and other tools. So a power of attorney can still be there. A family member might still hold the power of attorney that was created before the person became incapacitated, or a healthcare surrogate. The spouse might still be alive and may want to still make medical decisions and holds the healthcare surrogate designation. There may be a revocable trust or an irrevocable trust available. So all those things are going to impact the continuity of care. So things that you can keep in mind when planning long-term guardianship matters, you should consider these questions. So for example, for financial sustainability, are the ward's current assets sufficient to cover the care for the next 5 to 10 years? Long-term care costs. So what are the projected annual care costs? And how might these costs increase over time? At what point might Medicaid eligibility planning become necessary, assuming that they don't have it at the moment? Or another thing you can keep in mind, if the current guardian, because this is something that people don't really think about, if the current guardian can no longer serve, who's prepared to step in? Successor trustees, if a if a trust asset exists, is there a trustee who can administer them consistently? And is there a successor trustee in case that individual is not able to do so or just doesn't want to do it anymore? And then you should also think about emergency transitions and plan that out. If something unexpected were to happen tomorrow, is there a plan in place for immediate continuity of care? So those are aspects of the medical care that also get involved here, that you need to be thinking about and have a plan, a contingency plan, basically. So, so for risk mitigation, let's talk about that. And I believe that the slide, let me move the slide. Okay. Something is wrong with the slides. So we went through that, protecting the public benefits. We went through the special needs trust coordination so that, remember, that's the trust that you would create as the guardian once you have the authority or the permission granted by the court so that you can protect the SSI and Medicaid benefits of the ward. Okay. And you're going to always keep in mind how the award or the inheritance would impact. If it's going to negatively impact, then you immediately have to seek out counsel from an estate planning attorney that specializes in these types of things with special needs trust so that you can be protecting your ward. And then we talked about aligning the legal authority. These are all the common issues that you as the guardian have to deal with, and all the overlapping authorities. And then we talked about preserving the continuity of care. I apologize, the technology is not cooperating today, but doing the best I can so that I can get this information to you in as plain English as possible so that it's understood and that you can ask me questions at the end. So let's see what else. So one thing that I've observed over the years is that the most complicated guardianship situations don't really arise because someone made a bad decision. They usually arise because there's multiple people involved, but they did not have a meeting of the minds early or early enough. So, for example, the guardian might be managing the daily care of the ward, and the trustee controls the trust assets. And then a family member controls inheritance that comes in from a deceased family member. And then that person sends it, the personal representative for that deceased person sends it directly into the bank account of the ward without communicating with the guardian that was managing the daily care or with the trustee that is controlling the trust, instead of funding it into the special needs trust, assuming that the trust that exists is a special needs trust. So if they do it that way, it bypasses the trust, which is what you never want to do, and then it disqualifies the ward. So that's a real life example in plain English that I hope everybody understood. The main thing that you always keep in mind is how is it going to impact the benefits that my ward receives. And if there is a trust, you want to put it in the trust and you want to make it a special needs trust. And if there's no trust, then you have to seek out counsel, and the council will submit a petition to the court to give you the authorization to create the special needs trust. So the most complex cases are not really about documents. A lot of people just think documents and estate planning, but it's more about the coordination between the people that are involved. So I want to summarize the risk mitigation here. You've got to document your decisions early and clearly. You've got to confirm the court approval requirements. You always keep in mind to separate the trust and the guardianship assets. That's extremely important and can really give you a lot of liability as the guardian. And then always seek professional coordination early when any type of issue arises so that you're not scrambling for emergency planning, so that you're doing your best to protect your ward. So, like I mentioned to Sharon before we began, I created a resource for the audience. It's called the Florida Guardianship Risk Update. And I include a fiduciary risk checklist in there and just practical guidance that I have seen through experience for you as a professional guardian. And I believe there might be attorneys in the audience as well. And you're welcome to download it. I've got it on this. Let me see. I believe it's this one. Okay. If you scan that QR code, you'll have access to the guide. And I'm more than happy to help anybody, and you can communicate with me. You can reach out to me with any questions. You can actually, my email and all the information is here. And then you can, I keep looking to the side because I've got two monitors in front of me. Um, and you can scan that QR code for the guide. And I'm open to questions now. Sharon, if you have anything you want to discuss in more detail, I went faster than the 45 minutes, which might be good for the audience.
Sharon, you're on mute.
There we go. Okay. Yeah, thank you so much. Good things to think about there. We do have one question in the Q&A from Venetia. So I'm understanding that if a ward has a will that was in place before the incapacity, the will is honored before the preservation of funds in a special needs trust to care for the ward, question mark. Are we to spend down the funds without a trust? Help me understand. That's a good question. I actually wanted to talk a little bit about that from our trustee perspective too. She says that she has a couple successor guardian cases, and they have a will and money, but now they're young and the funds will most likely run out paying the nursing home. So can you speak to that a little bit, Sonia?
Well, I assume, is this a Medicaid, like a Medicaid trust that you'd be dealing with? Because that's typically what would happen there in order to qualify. I'm
I think
assuming the ward is not on Medicaid yet.
um, it sounds like it, right?
Okay. Yeah, so that would be yeah, a Medicaid, a mapped basically. It's a specific trust that, so first as the guardian, you would have to seek out counsel to petition the court to give you authority to open up a specific type of trust that is going to benefit the ward. And you're going to specify, or the attorney's going to specify on the petition that the individual is going to need Medicaid and that the trust is for qualifying for Medicaid. So that's always the goal, to benefit the ward, and that's what you've always got to keep in the front of your head, and the attorney that helps with the guardianship matter. And then that's what gives you the possibility of getting the authorization from the court.
Yeah. So I wanted to talk a little bit about that too, because, with the special needs trust and the pooled trust that Aged manages, we see this a lot with the guardians. And, we do have discussions sometimes about, does the ward have a will? And, if they do, in our pooled trust, and maybe other pooled trust companies allow to name heirs, but you can name the heirs in a pooled trust or in a D4A trust. After Medicaid payback, you can name the same heirs that you see in the will.
Mhm.
And when you are submitting your petition to the court, what we recommend is that you fill out the joiner agreement. Don't sign it until after the court order. Medicaid won't even accept the joiner agreement if you've signed it prior to getting your court order. But, so you're telling the court, you're showing to the court, because you're submitting to them that you've named these heirs. So you're trying to follow the will as much as possible, but you're also trying to qualify for Medicaid. And this way it's protecting you as the guardian, because you're still following the testamentary provisions, but you're getting your ward qualified for Medicaid to make their money last longer, so they won't run out of money, basically, and they'll qualify for Medicaid. So that's kind of what we, suggest as a way to protect yourselves and follow what Sonia was saying. Try to follow the testamentary provisions if there are any that you know of. That makes
Mhm.
sense. Yeah.
Yeah,
Yeah.
and the judges always look at that criteria, whether it's going to the same vein, basically, if you're keeping the wishes of the ward, because then it's benefiting the ward not just in the financial part, but also in their personal wishes. So you're doing your job as the fiduciary. You're actually doing a very good job that way,
Right.
keeping their intent in front of mind.
And I mean, some people want to name the estate, you know, um, which can can be done, but then you're looking at having to potentially open an estate. If there's going to be enough, if there is enough money left over in a trust after the in a first party trust after the Medicaid is paid back. And then there's money, and if you haven't named the specific heirs, then an estate would, and you've named the estate would have to be opened in order to receive that money. Which we all know can be expensive. But so there's, it is a possibility, but and sometimes there's not enough money. It just depends on when in our pooled trust, and we're writing, somebody passes away and you've named heirs in the trust. We write to Medicaid and say, here's a copy of the death certificate. Provide us with your lien amount. And so they keep track of what somebody spends on Medicaid. They have a system for that, and then they write a letter back and they give a dollar amount. So we compare that to, what is in the trust at the time. And if there's enough to pay the lien back, in a pooled trust, then we pay the lien back, and then the balance gets distributed to the heirs, whether it's heirs or the estate or whatever. So we like to have addresses and contact information. In a individually drafted first party trust called a D4A trust, and I'm sure Sonia does those a lot. A lot of times those are larger amounts of money. You have to be under 65 when those types of trusts gets funded. It's basically the same thing. You pay Medicaid back, and then you can name heirs in that trust after Medicaid. The difference is in those, since we got a little bit of time, those types of trusts, let's say, I'm going to give you an example. Somebody dies and there's $100,000 left in the trust. If it's a full trust, okay, and the lien is 200,000, we don't have enough money to pay back that $200,000 lien. And the trust company, Aged, is going to retain all that money and use it for our nonprofit mission. In an individually drafted trust, like what an attorney could do for someone under 65, a special needs trust, the lien is 200, but there's only 100 in the trust. You still have to pay that 100,000 back to Medicaid. All right. You pay partial liens back. In the pooled trust, you don't pay the partial liens back. So again, consulting with an elder law or special needs planning attorney like Sonia and really talking through all the different options is super important, when you're doing your planning. And I've seen a lot of times guardians that have great guardianship attorneys, but that guardianship attorney does not practice in the special needs area, doesn't know the elder laws and the special needs trust. And I've seen many times where that attorney would co-counsel with a special needs attorney. And that works really well. There's no reason why that can't be done. So that's always an option too.
Yeah, I've seen that often.
Mm-hmm. Yep.
Yeah.
Oh. Okay, so let me see. Oh, we got a couple more questions, it looks like. Robin says, I'm always interested to hear what people say is the point we should start planning for Medicaid eligibility. How much money the ward has available? That's a good question. Thoughts on that, Sonia?
No, to be honest, I mean, I would say when there's genetic uh syndromes in the family and things like that, where the person has a likelihood of something, dementia, so many things. I can tell you that it's different though, because it's not the ward. I can tell you that right now, because the economy is, people are waiting and just doing a lot more crisis planning than pre-planning. So I don't really have an answer. I'm curious to see what you think, Sharon, and what other people in the audience would say.
Well, and I know you talked about, looking at how much, as part of your analysis, when you are working with your wards or you come into a new case, what are their needs, and how long will their money last? And, like I was just talking to someone that was getting a lawsuit settlement with $200,000 and she's on SSI. So, you know,
Mhm.
actually was closer to 300,000. So the discussion was, and she had an attorney involved also, like you could lose your SSI and your Medicaid and take the 300,000 outright, but she's 23 years old. So what's important to you, was the discussion. And it was Medicaid. She had a lot of surgeries that needed to be done, you know, and if she just took the 300,000 outright, she's gonna have to, she didn't have any insurance to cover that, and all of that. So the Medicaid was more important to her. And so we opened the trust and we're paying things for her that she needs and being able to do things for her to supplement her lifestyle and all of that from the trust. So,
Exactly.
you know, a lot of time, it's that. And then what we see on the crisis, we see so much crisis planning from the elder law attorneys throughout the state for long-term care, someone going into a nursing home, someone's on the wait list and they get off, and now they still have, even 50,000, 100,000. Most of our pool trusts are less than 100,000. Some are not, though, some are a little bit more. Um, but think about your guardianship fees too. Like, you know, like average cost in a nursing home is over $10,000 a month. So if you qualify for Medicaid, all you have to pay is your income to the nursing home. So if your income's 2,000, pay the nursing home 2,000 and let Medicaid pick up the rest of that 8,000. Because if you got 100,000, it's going to last about a year. That's it. And, then how do pay your guardianship fees and all of that if you're private paying? So you really have to kind of do the analysis. What is the benefit of the Medicaid in my mind? And it's going to it's all about extending the life of the money. So if it's 2 million bucks and you don't have a lot of medical needs, you may not need it. If it's 100,000, you probably need to preserve it, and then it won't be a pro bono case for you either.
A lot of the
Um,
time, yeah, a lot of the time I mean, Medicaid it's just so expensive. The healthcare system, that example that you gave of the young lady that had the opportunity to get 300,000 outright, but she has surgeries. That might be two surgeries, and maybe if it doesn't get
right,
complicated and there's no rehab, there's no infection, there's no comorbidities happening at the same time. An ER visit, think about it, an emergency room visit that becomes a stay. That's
right,
going to be a few tens of thousands right there.
exactly. So Dana put, and I know there's another in the Q&A, but Dana put an example to consider: an individual with 120,000 who's 54 years old, life expectancy of 60. Okay, so only expected to live 6 more years.
Mm.
They receive SSDI and are in good general health with enough theoretically to fund them through age 60, you know. I mean, you never know how long somebody's going to live, right? And it depends on like what kind of Medicaid. We're talking to people all the time. What kind of Medicaid do you need? With SSDI, you got Medicare, you're spending a lot in copays. You could get medical Medicaid, by using a trust. Do you need long-term care? What's the cost of that? How long's the money going to last? So it's really so personalized to understand, like what can you save with a Medicaid? Is it medical Medicaid, saving copays and medicine cost, or is it long-term care and all of that? Let me go to Robin's. I mean, Lynn, if a public guardian that did not do their due diligence to protect a ward's public benefits prior to the ward receiving an increase in personal assets due to the sale of a home, does that change anything in your presentation? So Lynn is saying like the ward received sale of proceeds from sale of home, I guess, and that disqualified them from public benefits, you know. So maybe they didn't do their due diligence. Maybe they did, but maybe they didn't. Um, it's never, in my mind, it's never too late.
You can appeal and and then prove. I mean, for the guardian, that's a fiduciary duty, so there's going to be, explaining to the judge why they chose to do what they did. Um, but for the Medicaid or the benefits aspect, you can always file an appeal and submit that as the proof that the attorney chose, or not the attorney, the guardian chose that, and that's what's happening right now, and that now there's a new guardian
Yeah,
to support the argument, basically, you know.
right.
And I know
Cindy
that
said,
appeals are taking a long time, so hopefully that doesn't happen frequently.
Cindy McClyman says it's never too early to plan. I agree with that.
A lot of people think that planning is going to bring bad, you know, like going to bring death, or it's like you're already planning in a negative way. But I don't see it that way at all. I see it as getting peace of mind that you are okay. I mean, I think it can actually extend your life by giving you a better quality of life because you know that you are okay and that you'll be okay. So.
Right. And, you know, in that, along those lines too, make sure you're doing your funeral planning because, you know, when you have a first party special needs trust, when someone passes away, that trust can't pay anything. Um, you know, especially the pool trust, we're not allowed to pay anything after death um, that, you know, we haven't received prior to death. So make sure you've got your, you know, burial planning in place. Medicaid allows you to do that. Dana wants to know, please state the pooled trust assets requirements. So pooled trust itself does not have any asset requirements. A pooled trust, we have some trust with $100 in it because they're used for income only. Income comes in, we pay the bills for the month, so the money goes out, and then the income comes back in the next year, just kind of like a QIT. A pooled trust can be used like that. We don't have any minimums. We just have, you know, minimum fees. So depending on the situation. So most pooled trust, well, actually, I do know one that has a minimum. It's a small amount, but you know, generally there's no federal or state requirements for assets. So you're looking at what you're looking at for asset requirements is Medicaid, you know, $2,000 for long-term care, you know, for the medical, Medicaid, QMB, dual eligibility, Medicare, Medicaid. The asset requirement is almost not as over 9,000. You can have 9,000, you know. So it depends on what kind of Medicaid you're wanting as to what the income and asset requirements are. So, all righty. Well, I'm going to wrap it up here. Oh, wait a minute. Oh, did I see a couple more questions? How are structured settlements handled? Um, so let me take that one. We actually had a training on this the other day. Structured settlements can be assigned to a special needs trust, and we have several accounts where the structured settlement is is an annuity and it comes in every month, but the the payee should be the trust to keep it out of to protect it for Medicaid purposes. um, so the next question, just real quick, we got a couple new ones. Is a VA lump sum back payment permitted to go into special needs trust for 65 plus? Oh, Diana. Is a VA monthly payment permitted into a special needs trust if the person is over income for an ALF or a nursing home? VA, if you are the VA fiduciary, if there is a VA fiduciary, the VA administration, wants to keep your money separately accounted for. So you normally have a VA fiduciary account. Sometimes VA and Medicaid don't play together very well. We actually have a trust that we opened recently where the only thing going into the trust is VA money. Okay. So we're trying that. We understand that that has been tried and been acceptable from VA before because you can give them like the trust accounting and that everything in there is VA money. So where we have seen problems before with guardians where they're VA fiduciary and they want it, and let's say somebody has a settlement or whatever, they put money in to a pool trust that's not VA money, and then they want to add VA money, like that has sometimes been a problem. So, there may be ways to get around that, maybe, but VA, that it can be challenging sometimes. So we can always talk with you and your attorney and try to figure out if there's a way to do it. So, Sonia, any final words?
I want to thank everybody for being here. I hope that this was valuable to them. And I welcome you to contact me for any case or question that you may have involving probate, trust planning, special needs trust, any power of attorney question, and business succession planning. I'm here available and I'm happy to help. And the information for the guide will be provided to you as well in the PDF that I believe Sharon or someone will send out to you.
Right, right. Oh, thank you so much. This was fun to be able to chat like we did and very good information to think about. Our next webinar is April 8th, the second Wednesday, and I will be speaking with Mark Hendelson. He is a Social Security expert. And we're going to be talking about retirement, disability, survivor benefits, disability applications. And Mark is really in the know and has some information about changes coming up with Social Security. It should be very interesting. So I encourage you to come with your questions and join us on April 8th. Thank you all for attending. Make it a great day. Bye-bye.
Bye, everybody.